all things being equal, the document that she submitted to us indicates that she's approved to have rent that's owed to the plaintiff. The plaintiff is not satisfied with that because he claims that in order for him to get it, he's got to make a misrepresentation. However, independent research on our part indicates that that isn't necessary for him to do. And not only do we have to rely on independent research, we can rely on common sense. The government says, I'm going to help people who fall behind in their rent during the pandemic. The fact that they're not in the apartment at the time is not a condition to their reimbursing the landlord for the rent incurred during that time. But so it's irrelevant, really.
But the thing is that requirement that the tenant still be there, it does make sure that there's not more than one application for the same premises. Because if the person is there and the person's filling out the application properly, he's signing the same papers, it is protection just the same way the emergency relief requested said you must still be in the apartment.
Yeah, but I still don't see your point. What's your point?
The point. I'm so confused at this point. I don't even know if I had a point. Right. I think I'm just babbling.
But my point is that, in a sense, his lawsuit is premature. Unfortunately, he filed before he got the information. But essentially, he's going to be reimbursed, as far as I can determine, for the rent that's due.
Okay, now what you're saying makes sense to me, because now I get your point. So that he could actually end up double dipping if, in fact, she's approved even on false information, and he didn't have to sign anything to go along with that.
So the issue is,
so as far as the rent issue
to recover now
concerned,
from us? Or it's premature because the money is waiting for him?
I don't think it's fair for us to impose a judgment on the defendant at this juncture, given her representation that she has an approved application.
How about this as a suggestion? If what we believe is true, that there's a possibility he could be reimbursed, then why don't we dismiss that aspect of his case without prejudice? If he gets money, great. And if he doesn't get money,
I think it's a wonderful
he could
idea.
come back. And we'll resolve the damages.
The only damages for which I would hold her liable are those that she admitted. She admitted that her son punched the
doors.
The wall. Yeah, I would hold her liable for the walls. You know, he doesn't want to...
How much is that?
I think it was...
there are 2 holes in the wall that he punched through, and I think it's $675. Mm-hmm. Apparently, the doors... he claims came off the hinges.
I saw the doors off the hinges.
So he's claiming $360, and I can't imagine that she stayed there with the door off the hinges for 2 years. But it's beyond normal wear and repair. So we're talking close to $1,000 and change at that point. The mildew on the bathtub, no. She says they didn't break the blinds. I won't do the repainting, but I believe that the ripped screens and the vertical blinds.
His complaint, he's only asking for $635
over and above
damages.
The $2,000.
Oh.
So we're deducting from the security deposit $675 for 2 doors?
No, 2 doors, $360, $675 on the holes in the wall. I'm willing to do the vertical blinds, and I'm willing to do the window screens, just to see what that comes out to. That's 5, 13, 14, 19, 10.
And she's not trying to get any money back. She's not even trying to get any money back. So we can just...
So based on what we see, he's been more than compensated by his withholding her security deposit, which I'm fine with, because even if we include the things that we dispute, amongst ourselves, it's still under the $1,900 that he's holding on to.
So summing up, we are going to dismiss the rental cause of action without prejudice to his returning to us in the event that the process that she's already engaged in does not go through, where he is not reimbursed for the 3 months rent. He's going to be free to come back and make an application to appear before us to resolve that.
And to do it directly without going through the small claims.
And as far as the damages are concerned, we find that her security deposit more than adequately covers the damages, and we're dismissing that aspect.
Beautiful.